Hello, everybody. I apologize for that little snafu we had. You guys should be able to hear me now. Hello, everybody. All right. Sorry about that, everybody. My bad. Arthur jinxed me today. Normally, we are good to go. But, working with him and putting our heads together, we managed to figure it out, and we're good to go. Oh, technology can be wonderful, right? All right. Excellent. We did that old masterful trick. Everybody ready? When you don't know what's going on with your technology, of shutting it down and starting it up again. Who does that? Who does that whenever something's not working? They just shut it down and start it up again. Turn it off and then on. And then if that doesn't work, you're like, I don't know. I'm all out. Turn it off and on. If that works, great. If not, oh well. Congratulations, Stephen Osella, on passing your exam. Good stuff. Okay. So with that being said, we're talking about property transfer today. When we talk about property transfer, right, what should come to mind? What should come to mind first and foremost? What should come to mind first and foremost when we talk about property transfer? So when we talk about property transfer, the first thing that should come to mind is the word deed. Good job, Paige Wolf. First on the board, the word deed is the first thing that comes to mind. What is a deed? What is a deed? What is a deed? Okay, a deed represents evidence of the transfer. Do not get it confused with title, everybody. A deed represents evidence of the transfer. Okay? Evidence of a transfer. Somebody said it's like a receipt. That's a good example. It would be like a receipt when you buy something. Shows that you made that purchase. It doesn't necessarily show ownership. Okay? What shows ownership? So deed is evidence of the transfer. What shows ownership? What shows ownership? Title is ownership. Title is the ownership. Excellent job, everybody. Deed is evidence of transfer. Title is ownership. When you have title, you could have legal title or equitable title. What is the difference between legal title and equitable title? What do you guys think is the difference between legal title and equitable title? What is the difference between legal title and equitable title? Okay, legal title represents that right to sell, And equitable title is the right to use and possess and gain equity, all right? The right to use and possess and gain equity. That would make sense because it's equitable title, right, everybody? Who could define for me what is equity? What is equity? You guys are doing a great job answering the questions in the chat. I love the participation. It's what we need for everybody. What is equity? So equity represents your interest in the property above and beyond all liens against it. Your interest in the property above and beyond all liens against it. Okay, basically it's the money after you sell the property you can take home and buy a cookie with, right, everybody? So it's your interest in the property above and beyond all liens against it, which begs the next question of what are liens? What is a lien? Who could tell me what is a lien? What is a lien? Okay, so a lien is money that you owe. Everybody write this down. Everybody ready? Lien money, lien money, lien money, lien money, lien money, lien money, money, lien money, lien money, lien money, lien. You all write that down? Lien money, lien money. Are all liens encumbrances? Are all liens encumbrances? Okay, The answer is yes. All liens are encumbrances. Are all encumbrances liens? Are all encumbrances liens? No. You have things like easements, which are encumbrances that have nothing to do with money. All liens are encumbrances, but not all encumbrances are liens. Everybody got that? So that leads me to the first question we're going to do on the board. That was my segue to lead into this. Under which of the following types of liens can both the real property and the personal property of the debtor be sold to pay the debt? A, assessment lien, B, judgment lien, C, mechanics lien, or D, real estate tax lien? I'll read it again. Under which of the following types of liens can both the real property and the personal property of the debtor be sold to pay the debt? And the answer is B, judgment lien. So a judgment lien would be what's called a general lien. Okay, you have general liens and specific liens. A mechanics lien you guys see on the board would be an example of a specific lien. Taxes depend on whether it's property taxes or income taxes. So we're talking about the difference between general liens and specific liens. What is a general lien? So I said a judgment lien is an example of a general lien. So what does that mean? What is a general lien? What do you guys think? What is a general lien? So Audrey writes, general liens cover real and personal property. Just remember, it covers all property. It goes against everything. They could take everything. They could take your property, take money, take your car, take your firstborn if they want. Anything to cover that debt. Although I don't think your firstborn would cover the debt. That'd also be weird. Okay, so that's a judgment lien. It goes against all property. Whereas specific lien, they take one thing specifically. What is an example of a specific lien? Who could give me an example of a specific lien? Who here can give me an example of a specific lien? Okay, mechanics lien, property tax, a mortgage, good. These are all good examples of specific liens. Pretty Washington, income tax would be a general lien. Love that name, Pretty Washington. Okay, let's do the next question here. To alienate title to property, 1A, clouds the title. B, encumbers the title. C, records a homestead. Or D, conveys a title. Thanks, George. You rock. To alienate title to property, 1A, clouds the title. B, encumbers the title. C, records a homestead. Or D, conveys title. And the answer is D, convey. To alienate is to convey. It's to separate yourself. That's why when we say we feel alienated, we feel like we're on our own because we're separated from the group. Does it sound okay for everybody? I feel like it's pretty good, but if there's anything I can make better, just say so. But I'm feeling pretty good about my connection right now. But I always want to improve for everybody. We do have Adrian and Arthur on the chat today, so if you guys got questions, write them in the chat. And if you guys, Adrian and Arthur, would not mind posting links to our group and our Instagram and our Facebook page and anything else that you guys want to share, be sure to post those links in the chat. That'd be great. You can also post a link to our email of the day so everybody can get that. Angelica, if your screen is blurry, make sure you change it to 720 HD. Make sure you guys change it to 720 HD. So throughout the webinar, Adrian and Arthur will post different things in the chat that will help you to be part of our real estate exam community. Okay, next question on the board. Carol enters into a sale-leaseback agreement with Joe, under which Joe will become the owner of Carol's ranch. Which of these statements is true of the arrangement? A, Joe receives possession of the property. B, Carol is the lessor. B, C, Joe is the lessor. Or D, Carol retains title to the ranch. I'll read that again. Carol enters into a sale-leaseback agreement with Joe, under which Joe will become the owner of Carol's ranch. Which of these statements is true of this agreement? A, Joe receives possession of the property. B, Carol's the lessor. C, Joe is the lessor. Or D, Carol retains title to the ranch. And the answer is C, Joe is the lessor. Does everybody understand what a sale-leaseback is? Okay, so we see sale and leaseback. A sale-leaseback is when you sell your property and then you become a tenant of the new owner. This is very common when you have a commercial business as a way to get more money for your business. So you say, well, if I keep my property, the equity will grow, and that's great. But if I can take this money and put it into my business, I believe in my business, and I believe my business will make a lot more than the equity in the property would. So I'll sell my property, take that money, put it into my business because I believe in my business, and then I'll become a tenant of the new owner. So everybody wins in that scenario if done correctly. So basically, everybody ready for this? The vendor becomes the lessee. Okay? The vendor becomes the lessee. Has everybody got that? The vendor becomes the lessee. So vendor means the person selling, giving the property, and lessee is the one receiving the lease. All right? They're receiving the lease. Okay, remember that OREE rule. Lessor, vendor, grantor, give, or the proprietor. EE, lessee, vendee, grantee, gives me property, makes me happy. Adrian, looks like some people are still confused. Would you mind writing a very simple definition of a sale-leaseback? If you see one there, if you would not mind writing a very just simple definition of a sale-leaseback for the people who are still having trouble with that, that'd be great. Okay, when the grantor does not wish to convey certain property rights, he or she, A, may not do so since the deed conveys the entire premise. B, must convey the entire premise and have the grantee reconvey the rights to be retained by the grantor. C, must note the exceptions in the separate document. Or D, may note the exceptions in the deed of conveyance. Okay, and the answer is may note the exceptions in the deed of conveyance. Good. Excellent. Okay, next question. In a settlement statement, the selling price is always A, a credit to the buyer, B, a debit to the buyer, C, a debit to the seller, or D, greater than the loan amount. What do you guys think? Okay, in a settlement statement, the selling price is always A, a credit to the buyer, B, a debit to the seller, C, a debit to the seller, debit to the buyer, or D, greater than the loan amount. Okay, and the answer is a debit to the buyer. Debit is money that's taken from you. Credit is money that's being given to you. So the price of the home would be a debit to the buyer because that's what they're paying for the property. A title insurance company official would have known that an abstract of title is A, clause that describes the land, B, written summary of documents relating to the title of the property, C, standard form that is used in the industry, or D, closing statement from the title insurance company. Okay, so remember, an abstract. What do you guys think when we think of abstract? The word that should come to mind is the word summary. An abstract is a summary. What is the difference between a chain of title and an abstract of title? Who knows? Who knows what the difference is between a chain of title and an abstract of title? Okay, a chain of title is a history of ownership, and an abstract is a summary of everything involved. Everything involved there. The sudden tearing away of removal of land by action of water is A, accretion, B, erosion, C, aversion, or D, avulsion. The sudden tearing away of removal of land by action of water is A, accretion, B, erosion, C, aversion, or D, avulsion. And the answer is avulsion. A good example of avulsion would be like a dam breaking. Okay, so now we're talking about joint tenants and tenants in common. We'll do this question and then we'll get into a little more explanation of this. Stephen, his nephew, and his niece are joint tenants. Stephen sells his interest to his sister and then his nephew dies. As a result, which of these statements is true? A, the nephew's heirs are joint tenants with Stephen and his sister. B, the nephew's heir and Stephen's are joint tenants, but the sister is a tenant in common. C, Stephen's niece and sister are tenants in common. D, Stephen's niece and sisters are joint tenants. What do you guys think? And the answer is C, Stephen's niece and sister are tenants in common. Okay, so there's two ways you guys could own property. Do you know what they are? What are the two ways you could own property as it pertains to ownership? And it's really obvious. Don't overthink this. Do not overthink this, okay? The two ways you could own property, very simply said, is by yourself or with somebody else. By yourself or with somebody else. And that's it. Okay? You guys are overthinking it with all these fancy words like, freehold and less than freehold and all that different stuff. By yourself, with somebody else. Some of you nailed it by using the technical term of severalty and concurrent. Severalty and concurrent. That's the fancy way of saying by yourself and with somebody else. Severalty would be the technical term for owning it by yourself. Concurrent is the technical term for owning it with others. Everybody got it? Right? Got it if you got it. So concurrent is the idea of owning it with others. Okay? So severalty by yourself, concurrent is with others. Now, there's really not many ways that you could own something in severalty. You own it by yourself and that's it. You don't need special agreements with yourself. Concurrent, on the other hand, there's different ways you guys could own properties with others. There's two I want to discuss. Now, there are more than two ways, especially, as it pertains to your state. It could differ upon state. But there's two really that I want to touch upon. joint tenancy and tenancy in common, as those two apply to everybody no matter what state you're in. So what is the difference between joint tenancy and tenancy in common? Who knows? What is the difference between joint tenancy and tenancy in common? What do you guys think? Joint tenancy has the 4 unities of time, title, interest, and possession. Tenancy in common does not. What are those 4 unities? Time, title, interest, and possession, just as I said. Okay, to tip. A lot of you guys remember the term to tip. Tenancy common has only one of those unities. Which one of those 4 unities carries over to a tenancy in common? So joint tenancy has time, title, interest, and possession. Which one of those 4 unities carries over to a tenancy in common? What do you guys think? And the answer there would be possession. Possession is one of the 4 unities that carries over to a tenancy in common. Good job, everybody. There's another difference between joint tenancy and tenancy in common that some of you guys mentioned in the chat. What is it? So you got one that has the 4 unities and the other only has 1 unity. But there's another difference as well that comes up on your real estate exam. What do you guys think it is? So the other big difference is this thing called the right of survivorship. The right of survivorship. And that's what they're referring to with this question on the board. They're referring to the right of survivorship. The right of survivorship basically means that if you have a property as a joint tenant with somebody else, and if you survive them, meaning they pass away and you're still alive, then as the surviving member of the joint tenancy, you get the property. You have that right of survivorship. Has everybody got that? So therefore, the other joint tenants cannot will their portion of the property in case they pass away. Everybody got it? Right? Got it. Okay, a joint tenancy, you cannot will your portion of the property because the other joint tenants have the right of survivorship. If you wanted to will your portion of the property, you would take it as a tenant in common. You would not take it as a joint tenancy. Okay, now here's a question for you. Which one is more often used? The joint tenancy or tenancy in common? Which one would you see a lot more of? Joint tenancy or tenancy in common? What do you guys think? Which one do you think is more frequently used? Okay, and the answer would be tenancy in common. It's right there in the name. That's the more common one. Because as we discussed, joint tenancy has a lot more restrictions. You got to have those 4 unities. Remember, time, title, interest, and possession. Tenancy in common is not as restrictive, so it's much easier. The reality is you only use joint tenancy if you're really, really close with somebody because you're sharing everything. Time, title, interest, and possession, and the property goes right over to those other people. In your typical purchase, when you purchase with somebody else, it's usually going to be a tenancy in common. For example, if you and I go into a business deal and we like each other and we want to start buying properties together, it would be a tenancy in common. We wouldn't do it as joint tenants. Okay? So do joint tenants if you were like my brother or sister or something of that nature. If you take a property with a corporation, would it be as a tenancy in common or joint tenancy? So if I take the property with you, we have a choice of joint tenancy and tenancy in common, of which we said tenancy in common is more common. But if it's with a corporation, there's no choice. You can only take it as one of those. So if you take property with a corporation, which one would it have to be? And the answer would be tenancy in common. Tenancy in common. Okay? Has everybody got that? Why? Because corporations don't die. They dissolve. Corporations dissolve. They don't die. So the right of survivorship wouldn't work in that situation. So therefore, you cannot do it as joint tenancy. It has to be tenancy in common. Everybody got that? That's super important. It sounds like you guys are pretty much on it with that. So I'm happy about that. And that's really important. Which of the following would be an example of a boot for income tax purposes? A, an increase in deductible depreciation. B, a decrease in real estate property taxes. C, debt relief from a mortgage in the exchange. Or D, a decrease in basis. So which of the following would be an example of boot for income tax purposes? A, an increase in deductible depreciation. B, a decrease in real estate property taxes. C, debt relief from a mortgage in the exchange. Or D, a decrease in the basis. And the answer is C, a debt relief from a mortgage in the exchange. So before I could discuss that, we need to back up for a second before we get into anything about boot. We can't discuss a boot unless we understand what is a 1031 tax-deferred exchange. Who here knows what a 1031 tax-deferred exchange is? Some people say tax-free exchange, but it's really not tax-free because eventually you're going to pay taxes. Okay? So what a 1031 tax-deferred exchange is when you get a property, all right, and you sell that property, you take the money from the old property and you put it right into the new property. Does everybody get that? So you buy a property, and then when you sell that property, you take the money from the old property and you put it into the new property. This is a federal law, so this is not state specific. Everybody's got to know this. This is a federal thing. Okay? Now, why do they call it tax-free? Because you don't pay taxes on it if you take the money and you put it into the new property. Why is it not really tax-free? It's tax-deferred. Because eventually you're going to want to take that money out, right, and not always put into properties, and you're going to want to, have that money. At that point, you'll pay taxes on it. It's an incentive provided by the government to make sure people own property. The government would rather have people invested in property, all right, and take care of the property and take care of the community rather than take it out and put it in their pocket and not invest in the community. Does everybody understand that part? I hope so. So that's the purpose of the 1031 tax-deferred exchange. Now, a lot of you guys are writing down 45 and 180. The reason a lot of you are writing that down is because you have 45 days to identify the property and 180 days to close the deal. 45 days to identify the property, 180 days to close the deal on the property. Okay? Now, just to be clear, this is a type of 1031 exchange. This is the type you need to know for your exam. We're not going to get into the other types because you don't need to know it for your exam, so we're not going to do it. And there's people who specialize in this, of which you may be one of after you pass. Okay, but I want to emphasize that 1031 exchanges can get very elaborate and detailed and varied in the way you could do it. Okay, but the one we're talking about here, and the one that pertains to your exam, has 45 days to identify and 180 days to close the deal. Okay, everybody got that? Okay, good. Which of the following would cause a grant deed to be invalid at its inception? A, legal incompetence of the grantor. B, it was dated on a legal holiday, like New Year's Day. C, legal competence of the grantee. Or D, it was not acknowledged. And the answer is A, legal incompetence of the grantor. A purchaser obtains financing from local savings associations to purchase a condominium unit. In this situation, which of these best describes the purchaser? A mortgagor, B, a lessor, C, a grantor, D, a vendor. What do you guys think? And the answer is mortgagor. So if they obtain financing, which means they receive money, why do they have the OR in their name? Why are they the mortgagor and not the mortgagee? So if they are the ones receiving money, and we clearly describe that OR is the giver and EE receives, why are they the OR if they are receiving money? It says the purchaser obtained financing and they received financing. Why are they the OR? What do you guys think? Because that promissory note. Excellent. Because they are giving the evidence of the debt, the promise to pay. Nice job, everybody. As we discussed before, many teachers will say it's an exception to the rule, and it's not an exception if you understand what they're talking about, and it's a suffix. As Adrian is a great writer, he will tell you it's a suffix. Okay, so there's no exceptions to the rule. They are the mortgagor because they are giving the promissory note, which forms evidence of the debt, which must be received before any money is given. When an owner sues the government to get them to pay for taking his property, this is known as A, inverse condemnation, B, escheat, C, petition, or D, condemnation. And the answer is A, inverse condemnation. So what you have here is your four government powers, right, everybody? What are those four government powers? They are police power, eminent domain, taxation, and escheat. Police powers when they tell you how to use your property in ways such as building codes, zonings, things of that nature. They're not giving money to you. They could, I guess, but generally speaking, that's not what police power is about. Eminent domain is when they take your property and they give money for that. Okay, whereas police power, they don't take your property, they just tell you how to use it. In eminent domain, they tell you that they're going to take the property and they will give you money through this process of condemnation. If they do not give you the money that you believe is owed to you, or if they don't give you any money at all, then you would file what's called inverse condemnation, which is what brings me to what's on the board. That's inverse condemnation. And the other two is obviously escheat, which is when you don't have will and the government takes your property. And taxes, well, we all went over that before. Taxes are a lien, where you have to pay the government some money because you owe them. And they can be a specific lien if it's property tax and a general lien if it's income tax. Under federal income tax law, the basis of real property is the property's A, cost, B, fair market value, C, assessed value prior to resale, or D, purchase price minus any existing home loans. Now I'll read it again. Under the federal income tax law, the basis of real property is the property's A, cost, B, fair market value, C, assessed value prior to resale, or D, purchase price minus any existing assumed loans. And the answer is cost. Who knows what ad valorem is Latin for? What is ad valorem Latin for? Anybody know? What is ad valorem Latin for? Ad valorem is Latin for according to value. According to value. All right, guys. So that's it for today. For Adrian, Arthur, and myself, this is Joe from PrepAgent. I hope you guys had an amazing day. I will talk to you guys soon. Have a great day, everybody. Bye.